The following segment is sponsored by Gilman and Bedigian.
Governor Wes Moore signed the Child Victims Act of 2023 into law, which gets rid of the statute of limitation for victims of sex crimes against children. Survivors of abuse are praising the bill's passing, saying that the policy will help victims from across the state bring their abusers to justice.
Because this bill at the end will not undo years of suffering, but maybe it'll give us hope, make us better people. But I want you to know that I have tried, and I am trying, and I will continue to try, not just to change this world, but to be a better person.
So what does this mean for victims of abuse? What are the next steps? Attorney Charles Gilman with Gilman and Bedigian joins us this morning. Good morning, Charles.
Good morning, Patrice.
So talk about the law up until this point. Victims had up until a certain time to be able to come forward with some kind of allegations and lawsuit.
Well, in the civil aspect, up in 2017, the legislator had amended the statute to give you till the age of 38 to file a lawsuit for sexual abuse. This year, just recently in the last 30 days, they've abolished the statute of limitations on these types of claims. So that means you can bring a claim at any time. It doesn't matter how old you are.
So what do you think this means now? Do you think the floodgates will open? I see all of a sudden now the billboards that are up. I see a lot of commercials running. Do you think a lot of victims are going to come forward?
Look, for their sake, I hope that they do. There's certain victims that it's going to help them to come forward, talk about it, and it's going to be cathartic. There's other victims who have probably moved on and have to do what's best for them. So it really depends on the particular victim. But for those that this will help, it's going to be a big help.
So what does a victim do now if they do want to pursue a case? What are the next steps?
Well, it's like you said, obviously I'd advocate that they call a law firm that handles these types of cases. And like you said, there's buses, billboards, TV ads, all of it's going on right now. So you just have to pick a law firm that you like. Our firm handles it. But if, look, working with a lawyer is getting into a relationship. So call around or submit a few web forms. See which law firm you want to work with, which one you like, and then if it's the right thing for you, move forward.
And so then how does the process work from that point? How do you determine civil damages for abuse, especially something that may have happened years and years and years ago?
But there's going to be two components to it. There's going to be the economic harm, which is measurable because you had therapy, you might have lost time from work or that type of stuff that we can put a dollar value figure on. So that's the economic component. And then there's going to be the emotional component, which is the pain and suffering, which you really can't put a dollar value on because it's different for everybody. It's different in every situation. And look, I guarantee you, if I offered you $100 million, you wouldn't say, let me go get abused by somebody. So by way of example, it's very hard to quantify the pain and suffering or non-economic damages. However, the statute does cap those.
And what is the burden that must be met to prove your case? Is it as stringent as it would be in a criminal case?
No, in a criminal case, you're going to have beyond a reasonable doubt, which is a little bit more, you have to tilt it more towards the prosecutor on the scales of justice. In a civil case, it's going to be by a preponderance of the evidence, which is 51-49 in favor of the plaintiff.
All right. Charles Gilman, we appreciate some insight on this. Thank you so much.
Thank you, Patrice, and have a great day.